Good morning, good afternoon, and good evening to everyone joining us today from wherever in the world you may be. Welcome to the InvestAmerica webinar, where today we will be discussing the new EB-5 regulations that were recently enacted and scheduled to go into effect on November 21st, 2019. My name is Mike Xenick, and I will be leading the discussion today. I'm joined by Robert Devine of Baker Donaldson Law Firm, one of the premier immigration attorneys and law firms in the EB-5 arena. First, a couple of disclaimers. None of what we discuss today will constitute legal advice, nor should any of the information constitute an offering of any securities. One thing of note, at the bottom of your screen, you should see a Q&A button. Throughout the presentation, should you have a question, please click on this button to submit your question. We will address as many questions as we can at the end of the presentation. Also, on our team, we have a Portuguese and Spanish translator, our Global Development Coordinator, Mila Dialano, who is on the webinar. So feel free to submit your questions in Spanish or Portuguese, and she will be able to reply to you in your native language. So with that, let's get started. First, I'm going to introduce Robert Devine, shareholder with Baker Donaldson. I'll let Robert introduce himself and his firm.
Thanks, Mike. So I've been practicing immigration law for almost 35 years, and I have written a book on immigration law called Immigration Practice that's used by immigration lawyers around the world, and particularly in the United States. In its 15th edition, I was appointed at one point as the chief counsel of USCIS, and for a while I was the acting director of USCIS that oversees the EB-5 program. And after returning from the government, I got involved in EB-5 practice again and was elected 7 times for 7 years as the vice president of IUSA, which is the Industry Association of Regional Centers. So we've put together hundreds of EB-5 offerings for projects and have represented thousands of EB-5 investors in their use of EB-5 investment to get permanent residence. So I hope we know what we're talking about.
Great. Well, thank you very much for that, Robert. Robert and I have been known each other for quite some time and work together very well. Again, my name is Mike Xenick. I'm the president and CEO of InvestAmerica. InvestAmerica is a broker-dealer affiliated firm that works with regional centers and EB-5 sponsors to raise EB-5 capital for their projects all throughout the country. We've been around since 2012, and I personally have been involved in the EB-5 space since 2010. We've represented approximately 320 families during that time, helping them to navigate the EB-5 journey in a variety of ways. Because we're a registered securities firm and because we have a duty to protect investors, we actually, even though we don't represent the investors directly, because U.S. securities laws were only created to protect investors, we have to make sure that we are also serving the investors. And we do so from the moment that we meet them and introduce them to our firm and the offerings that we provide, all the way through to the end of the investment, which could be 5, 7, or many years later. So unlike other agents, we are there after the investment is made. Our firm has a broad base of experience raising other types of capital as well, and we also serve to protect and provide compliance services to our project clients. So with that, we will get into sort of a real quick synopsis of what we're going to talk about today. I'll leave this up for a minute. We're first going to have a quick poll. We're going to talk about the EB-5 regulations and we're going to talk about the key items. We're not going to go into too much detail about the things that aren't very relevant to EB-5 investors. We will talk about what this means for EB-5 investors, other things that may not be apparent that you need to think about and consider. We're going to talk about how both of our firms can be helpful, and then we'll do a quick overview of the projects that InvestAmerica currently represents in the EB-5 space. And lastly, we'll finish it up with some questions and answers. So first, let's go ahead and take a poll. It should be launching up on your screen. Please answer this as accurately as you can, and then we'll move on. All right. Thank you for that. Appreciate all of your answers. So next, let's talk about the regulations. I'm going to be talking and be turning it back and forth to Robert on various topics, and we'll be interacting, going back and forth. So first, the biggest change that I think everybody is most interested in, especially the investors, is that the increase in the investment amounts will be substantial. It's an 80% increase. Obviously, the increase, there has not been an increase since the program was implemented in the early 1990s. Most of the projects right now are in targeted employment areas as it is currently defined, and the investment is $500,000. That price will be going to $900,000 from on November 21st and afterwards. And for projects that are not in qualified TEA or targeted employment area, the price will go from $1 million to $1.8 million. So an 80% increase in both prices. They maintained the 50% differential between a TEA and a non-TEA investment. So obviously, we'll talk about the opportunities in a little while. This is a substantial change to the investment amounts that will be going into effect, slightly over 110 days or so from now. So with that, I'm going to let Robert talk a few minutes about the changes in the TEA qualification, and also how those target employment area designations will be determined going forward. Robert?
Okay. Yeah, let me tell you about the changes in the TEA. So a targeted employment area is a concept created in the 1990 Immigration Act that created EB-5. And it says if an investment is made in a targeted employment area, then the investor can invest a lower amount that the agency has set, which now is about to be increased to $900,000. So to be able to invest that level instead of $1.8 million, the investor needs to be placing their capital into for use in a project that will be creating the jobs in a certain area that's either rural, so out in the countryside, or in a high unemployment area, so that has a high unemployment rate of 150% of the national average. So the definition of a rural area is not changing. That is, it has to be an area that is both not in a town of 20,000 or more and not in a metropolitan statistical area designated by the Office of Management and Budget, often referred to as an MSA. When you're outside of a town of 20,000 and outside of an MSA, you're out in the country. You're not in any kind of big city. There's not many places. That's really fairly rural. So otherwise, if it's not in one of those rural places, it has to be in an area that has an unemployment rate of 150% of the national average. So if the national average is unemployment rate of 5%, then it needs to be 7.5% in this area. And the issue is what kind of area can be designated as high unemployment. Up to now, it's been possible for developers of projects who want to put a project in an area that would be pretty nice area where the economy is going well and a business could be expected to thrive. They could define an area of a collection of contiguous census tracts, which are little subsets of geography, and they could have a kind of a snake-like shape that might go from this nice area where the project is happening over to some beleaguered area where there's a high unemployment rate. And as long as the weighted average of unemployment rate for the entire area is 150% of the national average, then that could qualify. Under the new rules, that's not the way it will work. Under the new rules, it would be either if you had an entire city or an entire county or an entire metropolitan statistical area that, according to published data, has 150% of the national average, then that's a targeted employment area. But that's very rare. It's very rare that an entire city, county, or MSA fits the requirement. So usually it's some very local area. And under the new regulation, it has to be super small area. So either the census tract in which this project is sitting has to have 150% of the national average unemployment rate, or that census tract plus any combination of the census tracts around it that actually touch that tract have to have a weighted average of 150% of the national average. So this is really much narrower of a concept, and in the regulation that USCIS published, they said that maybe only about half of the projects that have been getting EB-5 investors in the recent past would qualify under the new rules. So a lot of projects that currently qualify will not qualify under the new rules, which means that an investor in one of those wouldn't just have to invest the $900,000 that is the least anybody could invest. They would have to invest $1.8 million in those places. So that's the effect of this new TEA regulation.
Great, thank you, Robert. Appreciate that. And I guess as far as how those are determined now and how they will be.
Yeah, let me mention that real quick. So as I mentioned, a whole city, county, or MSA could have a rate of unemployment that would qualify in rare instances, and that would be shown by just presenting the published data. Simple enough. For the other, for in any of those sort of bullseye designations of the project census tract or the ones touching around it, that would be according to data that basically an economist would pull together from available data under a couple of different data sets, and it would be given to the investors who would include that information in the filing that they would make for their green card based on the investment they've made. There's no process for getting the area designated beforehand, so that an investor has to kind of worry, well, is this even going to be effective? Is the government going to determine when my case is adjudicated that this is a high unemployment area? I mean, a responsible seller of a security should get a very clear economist assessment and show exactly how this thing will be determined to be in a targeted employment area. And I think for the most part, the data will be clear enough. But the government hasn't even clarified exactly which data sets are acceptable to use. They did mention two different well-known, commonly used data sets in their regulation, but they didn't say that in all cases, every one of those types of data would always be okay to use, and they didn't say what other types of data would be used. And there may be people who are tempted to, who want to develop a project in a certain area that could potentially qualify under an aggressive approach. They may be tempted to present that or to sell that in the market, and investors need to be careful to determine whether the TEA proposal that they're investing under is really solid or whether it's some kind of aggressive thing that might not get approved.
Right, great. Well, appreciate that answer, and I know it's going to be probably a little bit of chaos as we make that transition to how these TEAs are confirmed and documented. Let's talk very briefly also, if you would, about what the new regulations do to the priority date retention for approved investors. And I don't want to spend too much time on it, but if you could just touch on that for a couple minutes.
Yeah. It is an important thing that's been done that could affect, some people. Let's say that you invest in a project and before you can get your I-526, the first stage in the process, approved, or if you have to wait after that for a visa number, before you can get a visa number, something goes wrong with the project and it has to be radically changed. Let's say you get your I-526 approved, but before you can actually immigrate, you may be waiting, maybe you're from China or India or Vietnam and having to wait, 8, 10, 12, 16 years, in the case of China, to wait for a visa number. And while you're waiting, something drastic occurs that would be considered by the government to be a material change to the project. Or maybe the whole thing flops and you're going to invest in something else. Maybe you can get some money back and invest in another project. What this new rule says is that if you've had an I-526 already approved, if some material change occurs and you want to file another I-526 petition for a different investment or even the same one if something massively changed, then you can retain your place in the queue for a visa number from the filing date of the first I-526 petition. So that could be very helpful for the people it helps. It doesn't help a whole lot of people because if your I-526 the first I-526 gets denied, you can't use the place in the queue that was marked by when you filed that. If your I-526 gets approved and then you actually use it to immigrate and then something falls apart after you enter the United States and before the end of that 2 years when you have to file an I-829, in that situation, this rule would not help you and you wouldn't get to carry that original place in the queue to a new I-526 petition. It also doesn't help anybody who's trying to immigrate also in a different category. So a lot of people from India and China are the beneficiaries of some kind of employment sponsorship where the employer files a form called I-140 instead of I-526. And in that world, if you change from one job to another and the next job sponsors you for a green card, then you can apply, you can kind of hold the place in the queue from the first filing and by the first employer and processing for a green card based on the second employer. The important part about that is there's no cross-pollination between these I-140s in the employment-based second and third preferences or even first preference to this employment-based fifth preference, EB-5. So you can't carry an I-140 priority date to an I-526 project or filing, and vice versa. So you can only hang on to an I-526 priority date in filing a second I-526. Sorry, that's a little technical and complicated, but for the people it affects, they know what I'm talking about.
Sure. Okay, great. Well, thank you for that. And obviously, that's important for people that have invested and unfortunately may have not had success in their current project. Last bullet point on here, as we said and we'll say multiple times throughout the presentation, and you would probably see in lots of EB-5 notations from now till this date, is it goes into effect on November 21st, which is an extremely important date to remember for those that may be interested and have been interested in EB-5. So let's go to the next slide, and we'll talk about some of the ramifications. As I mentioned, there's any investor that gets in, who invests, subscribes, and files their I-526 petition prior to November 21st will be able to get in under the current investment amount and TEA designation. So any projects that qualify right now, you'll be able to invest in those. And it's important to note that while November seems a little far off, it's actually really close, and it's having, and I know Robert can attest to this as well, having been through hundreds of cases and filings for, if not thousands. It takes a while. Got to make sure that you have all of your information together. Source of funds documentation is extremely important to be able to be done in a comprehensive and complete manner. And when we say November 21st, essentially it means that your package really needs to be ready on no later than November 19th. So it will get to USCIS by the 20th. And I know but Robert and I can give you more details on what it will take to get your application done, and that is a multitude of things, including gathering all of your family information, and as well as working with the project and getting all the project information. So if you've not started down the process at all yet, now is the time to get started to evaluate the project and be able to get through the process in time. Obviously, 80% increase in investment amounts. So the benefit that you'd have on investing $500,000 on a qualified project by November 20th, you're going to get the same exact benefit the next day for investing $900,000 and hoping that the project still qualifies as a TEA. So there's a huge difference and a huge issue for investors as they're considering investing in an EB-5. And I would reiterate that we certainly don't want to rush anybody, and certainly don't want to get anybody to panic. There's still plenty of time to get your process started and get your application filed. But just to be aware that this change will substantially affect you and any of your friends and family that might be interested in an EB-5. So now's the time to move forward. Also, as Robert talked about a few minutes ago, the TA qualification is not going to be officially determined, ahead of time, like it is now, by getting a letter from the states to determine a TA qualification. Going forward, it will be, unless it's in a rural or non-MSA, you're going to be waiting for, and there's you'll be able to determine if it is, but you won't get that official word until the first investor files an I-526 for that project and/or they get an exemplar approval. So that's just something to keep in mind on that as well. So let's talk a little bit about the potential effects for investors that are already invested in a project. And there's a few things to consider here. The two biggest ones are, will the project that you're currently invested in still qualify as a TEA on November 21st? And that's important if for a couple different reasons. Number one, if it's not, obviously the project will need to seek investors at the $1.8 million level, and that may be a very difficult thing to do because obviously the number of people that can afford 1.8 million versus 500,000 goes significantly down. Now you need less investors to fill the remainder of that offering. However,
well, Mike, let's also recognize that, you know, given the availability of the opportunity to invest 500,000 for the next 3.5 months, that by the time that period is over, there are not going to be many people who are willing and able to invest $900,000, even $900,000. So,
oh yeah, sure.
Anybody who doesn't raise all the money they need from EB-5 before November 20th is going to have one heck of a hard time raising any EB-5 money in the months after that. Now, over time, there will be people who newly come along who didn't get on this train while before it left the station, and who may be willing and able to invest $900,000. But it'll be a slow, very slow go, hit or miss, for a good while.
Absolutely, totally agree with that, and you know, this is important if especially if a project is not fully capitalized, fully funded without EB-5. So there are many projects out there right now that are utilizing EB-5 to replace a bridge loan, or a the developer has bridged that gap with their own money, and those projects will likely be okay. But the ones that don't, the ones that are counting on EB-5 to complete their funding and to complete the project, that will be problematic, could be problematic for them in a big way, because if they're not able to finish their financing, the project may not be completed, job creation may not be fully realized, and ultimately if the project's not built, you know, the investment will be, you know, in most cases lost at that point. So it's something for people that are already in projects to consider as we get closer to November 21st. And then for prospective investors, the things we just talked about are also key. If you're looking at a project right now, the things that you want to look at are, is this project fully capitalized without EB-5? Are they already generating jobs? Will it be, is it contingent on EB-5 money coming in to be finished and to, you know, be able to complete the job creation and have a viable business once it's built? That way there's an opportunity for you to get your money back. And that's also...
Yeah, Mike, I would say, this is Robert, I would say there are two really big questions that an investor needs to ask somebody who's offering an EB-5 investment. One is, where is all the other money going to come from to make this thing actually happen? And how are you going to deal with it if you don't get as much EB-5 money as you're looking for? That's one question. The other question is, what are you going to do with my money once you get the project built and maybe it gets sold or refinanced and the money comes back to the entity that I'm investing in during the period that I'm waiting for my visa number and the 2 years after I get into the United States, which could, for people from certain countries, could be quite a long time. You know, what kind of redeployment are you going to do with my money? Those are two huge questions that should be asked.
Sure. Yeah, and you know, we're not really touching on redeployment in this webinar, but I agree. You know, there's there's going to be a long waiting period, most likely longer than probably than we've ever seen for people from all countries, and it's going to be again, probably multi-year wait before that first I-526 gets adjudicated. So next we have a poll question, and this is basically just to give us an idea of what country our viewers here today are calling from, and please answer this. I know we didn't have room to add lots of countries, so apologize if your country is not on here. The area of the world that you're calling from is not on here, so please answer that in a minute. And I'll take also this time to remind you that if you have a question, please click on the box at the bottom, the Q&A link at the bottom, and type in your question and submit it, so we can address those in a few minutes when we get to the end of the presentation. All right, thank you very much. So let's move on to other thoughts and considerations. So the other date we have upcoming much more quickly than November 21st is the September 30th sunset date of the Regional Center EB-5 program. And obviously between now and then, Congress is going to need to do something to reauthorize or extend the program for it to continue to be actively, for it to continue to be an active program. And there's a variety of ways that they can do that. So Robert, if you could just spend a minute talking about what Congress needs to do between now and then, and what this might mean for some.
Yeah, first we need to remember that if an investment doesn't involve the sponsorship of a regional center, then the law about that type of investment does not expire on September 30. Now, it does get affected by the regulations, so let's don't confuse this. Somebody who wants to do what we call a direct EB-5 investment, where they put the money directly into the entity that will employ full-time 10 operational workers without getting to count any indirect workers or any construction impacts or anything. Those kinds of investments, they don't need a regional center. The law about them doesn't possibly expire, but the regulations do take effect to increase the amount of the investment that's required to $900,000, and the targeted employment area that lets it be $900,000 instead of $1.8 million is still a narrower notion. So all those things apply, while the law that makes the overall thing work doesn't expire. For investments that involve a regional center and to count indirect jobs and may have indirect arrangements, those are subject to a law that is going to expire on September 30, and it needs congressional action, a law to be passed to extend that. I have every reason to believe that the law making that possible will be extended. The question is, I mean, of course, there does have to be a law, and there could be politics that could interfere with that. But I think the chances of no extension at all are very small. But there is the possibility that there could be changes to the law as Congress looks at extending it. Certain people will be pushing hard to get changes to the law. All the big city developers who now are not going to be able to get a TEA designation for their location and would have to only offer $1.8 million investments are going to be pushing hard to get Congress to override the regulations and pass a law that maybe says the minimum investment is $800,000 and the other level is like $850,000 or $900,000, something with a very small difference, so that investors would be willing to do the higher level, even if it's not in a targeted employment area. if there is anything like that going on, there would be horse trading, as we call it, and there probably would be new requirements that people call integrity provisions, that are a bunch of requirements on the regional centers and the issuers of these securities, the new commercial enterprises, and on the job creating enterprises, to ensure that they're compliant with securities laws and handling the money properly and so forth. And those are all probably good for investors, but not really affecting so much what kind of investment to make. So we don't know what's up next. I doubt that there would be any changes, any override of the regulations that will be successful. But people are trying. I do believe that there will be an extension of the program in general.
Okay. Yeah, I'm seeing and hearing the same thing too. Except for when the government shutdown happened in December. Every single time since October 1 or September 30th of 2015, they've had some type of extension that has kept the program going. And I think they certainly realized that these new regulations are in effect, and the program is still viable and still moving forward. I think we're going to be hearing a lot of chatter, I think, between now and September 30th in particular, about efforts that are going on, lobbying efforts by very large developers that may look to change some things or get Congress to act or do something to extend the effective date or do any variety of things. And as you said, the success of those efforts are in question. We'll keep an eye on that, and we'll certainly be able to provide additional feedback and additional commentary on that through our various information sources as we go through. Can you comment for maybe a couple minutes on how the new regulations might affect retrogression, and particularly, I think we talked a little bit about the backlog of 5526 adjudication in general, but
okay. Yeah. Retrogression is a kind of is like an inaccurate reference in a way to a phenomenon that really is about the unavailability of visa numbers, and the idea that they're becoming more unavailable as more people pile into the EB-5 program. There's 10,000 visas available or almost 10,000 available for the world. That's including investors and their family members every year. And that's the limit on how many people can be admitted in this program. There's no limit on the number of investments that can be sold. There's just a limit on the number of people who can get a green card based on those investments every year. And what's been happening is there have been more investments sold than there are visa slots. And the law says not only is there a worldwide limit, but there's a limit of no people born in any one country can use no more than 7% of the numbers in any given year. So that's basically no more than about 700 numbers, which might equal about 250 investors per country per year. And what's been happening is that people from China have been mainly the participants in this program. The rest of the world hasn't been using up more than 1,000 or 2,000 visas a year, so it's still left really 8,000 for China. They weren't just stuck with 700; they could get, a lot more. The rest of the world now has been getting up to maybe 3,000 or 4,000, or maybe 4,500, and that's starting to crowd China to where they're having to wait longer and longer behind each other. And the more people invest from other countries, the longer the people who already invested from China are having to wait. And there has become a waiting list for India and Vietnam. Those waiting lists are longer than they appear by looking at the visa bulletin. The people at the front of the queue maybe have waited a couple of years, but the people who are investing now are going to wait 6 or 8 years for their green card. And what's about to happen is that all these additional people, maybe from China, definitely from India, probably from Vietnam, also from Korea, and maybe from Hong Kong, are going to invest in Taiwan, are going to invest in some pretty large numbers, and more than 700. So the people who invest at the back end of this, right before November 21, are going to wait maybe years longer than people who invest tomorrow. So it's not only important to invest and file your I-526 petition, which is what marks your place in the queue, before November 20th, but it's important to invest it as early as possible before November 20th so that you mark your place in the queue earlier than all these other hordes of people who are about to invest during this period of time.
Absolutely.
And it's also possible that there will be a worldwide waiting list. If so many people invest that, even just allocating 700 people to China, Vietnam, and India, so that's what, 2,100. Then you've got 8,000. If a total of, maybe 3,000 investors with 2 family members invest, that would eat up the other 8,000. So if you had 10,000 investors from around the world who invested during this period of time, there could be a waiting list that would affect everybody. Not very long. It's not going to really hold up people from other countries besides the ones mentioned for very long, but it could be a little bit of a wait.
Sure. And I think, as you said earlier, once we get to November 21st and the new prices go into effect, there will be a substantial drop-off of applications for at least some period of time, and ultimately, I think we'll never probably see the level, or at least it'll be a while before we ever saw anything close to the level we saw before. So there
will, Mike, but the pig will already be in the mouth of the snake, if you get my analogy. And the pig has to be digested before, a new rat could be eaten, but could get through the process in the snake. So anybody who's going to invest, there won't be many people who invest after November 21, and those people will be waiting behind all the people who already invested at the $500,000 level before November 21, which is going to be even more discouragement to invest at that higher level for a while.
Sure. That makes perfect sense. Okay. Thank you very much for that. We're going to move on now to how we can help. And again, if you have any questions of anything we've talked about so far, how this may affect you, etc., please click on the Q&A link at the bottom and submit your question so we can answer it here in a few minutes. So I'll talk a little bit about how each of our firms can help. First, InvestAmerica. As I mentioned before, we've been doing this since 2012. We've worked with over 300 families to help them through their EB-5 process. Our focus is on heavy due diligence on projects before we agree to represent them. We make sure that probably more so, if not the most so than anybody, we do background checks on the management team and the regional center owners. We evaluate the financial projections and consider the reasonableness of those projections based on prior history of operations of that particular developer. So if it's a hotel developer, we look at all the hotels they've developed and operated prior to that. How successful were they? What are their occupancy rates? What types of things have they done to be successful? We look at the geography of where they're building the new hotel. Is there a need for a new hotel or a new apartment building or a new office building or whatever the asset is? We make sure that the EB-5 portion of it is structured properly, and that usually is satisfied by looking at who's involved, who is the EB-5 business plan writer, who is the immigration law firm or securities law firm or economist that have been involved in the project. Have they done this before? We look at the exit strategy. Is it viable? Is it pie in the sky? Is it something that will never happen, or is it something that's more likely than not to happen? We look at how much EB-5 is in the capital structure. If EB-5 is a majority of the capital structure, then we look at, we wonder, why is the developer not putting in, more of their own money to have risk alongside the EB-5 investors? Why is there no institutional capital, banks, other lenders in a project? So those are the kinds of things that we look at and we evaluate very, very heavily. So most of the projects, or any project that makes it through our due diligence, has been through a very rigorous analysis. We do this to mitigate the risk and maximize the opportunity for the investors. So our projects are very conservatively structured. There's never an elimination of risk, but there is a mitigation of that. And we always tell people that just because your capital as required by the program needs to be at risk, it doesn't mean you have to invest in a risky project. So we can, just the projects we offer, and we'll talk about a couple of them in a minute, offer advantages in that regard. As I mentioned before, we're also a registered securities firm through Sequence Financial Specialists, and we are required to protect the interests of investors, even though we represent the projects to raise them capital. We can help investors and guide them and their families through the entire subscription, investment, and immigration process alongside immigration professionals like Baker Donaldson. And we also like to provide a portfolio of options for people. Again, we'll talk about that in a minute. Different people like different asset classes, different capital structures, different locations. So we like to provide a variety of options for investors to look at. So we're available anytime for you to email us, call us, and talk about your immigration goals. Robert, talk just a minute about what Baker Donaldson can do to help them in their immigration process.
Yeah, the biggest part about investment for immigration is, aside from making the investment, is applying for the immigration benefit. And that involves, particularly at the beginning, showing where does your money come from. The government requires that the investors show that the money was not illegally obtained. And the way to prove that negative is to show where did it come from. And that can be a complicated procedure looking back many years. If somebody's selling a piece of property, for instance, to then generate the money to invest, they have to show not just about the transaction to sell the property, they have to show where did they get the money to buy the property, and to show that back to the point that they earned it, so they can show that it was not the proceeds of drug trafficking or human trafficking or who knows what else. So it's a significant paper chase. It needs to be engaged in as early as possible with a lot of urgency in this environment where the filing needs to be made quickly. We've done this thousands of times, and we have people available who can work with investors in doing that. We do not help people decide which investment to pick. We're not a registered broker-dealer. That's what InvestAmerica is. They're a registered broker-dealer who helps people look at what's out there and pick what's appropriate for them. We help people who have made the decision to invest, and we help them pursue the immigration benefit based on that investment. We can start helping them before they actually make the decision of which investment, so we can start working with them on showing where that money comes from before they actually make the investment. But we won't be involved in deciding which investment to pick. We just help them pursue the immigration benefit, both in filing for the I-526 and then later applying for the visa or adjustment status when the 526 is approved and the visa number is available, and then later to file the I-829 to remove conditions 2 years after they entered the United States. So that's the ways we can help people. And we can also help them in trying to figure out other options to be here in the United States in the meantime through some temporary visa or so forth. And otherwise, once they get here, to turn around and sponsor family members or do other kinds of business and so forth. So anyway, Mike, I'll step back and let you talk about the actual investment. Our firm does not, I'm required by our general counsel to say our firm does not endorse or promote any particular investment. I always say that everywhere, and because I'm required to say it. We just represent people in pursuing the immigration benefit. Thanks for letting me participate in this.
Great, thank you, Robert. And again, Robert and Baker Donaldson are one of the premier EB-5 immigration law firms and attorneys out there, and they can represent you very well in the immigration process and all the things that they can do. So appreciate your participation and
well, and I'll be here for the Q&A session here as we get ready.
Absolutely.
Okay.
Okay, so let's talk a couple minutes about our projects. We have 3 projects currently, 2 regional center projects and 1 direct pool project. We talked about a direct a few minutes ago about it not being affected by the reauthorization. And again, as Robert said, direct would still be subject to the changes of the new regulations, i.e. the price increase, as well as the TEA designations. So very quickly, again, all these projects have been through our rigorous due diligence process and are out for investment currently. The first is a New York-based project. It's a mixed-use facility. It'll be a combination of multifamily, office, and retail space. It's actually, in the picture you see, it's the building on the far left. It's located in Brooklyn on the East River overlooking Manhattan. They have a very favorable escrow structure in that 100% of the investor, $500,000 for now, will sit in a protected escrow account until your individual I-526 petition is approved. If it's not approved for some reason, then you will immediately get your money back. You'll immediately get a refund. If it is, then your money will go into the project. It's a very unique feature that very few, if any, projects have these days. Obviously, lots of job creation, over 47 jobs per investor. The requirement is 10 jobs per investor, so there's plenty of jobs. And I think at this point, based on the construction progress of the project, there have been more jobs created already for all the investors eligible for this project. It's fully financed, meaning that the developer has bridged the EB-5 money, and especially because of the escrow structure, would need to have happened anyway because they weren't reliant on EB-5 capital. The EB-5 represents only 9% of the capital structure, and the developer has put in over 30%, not including the bridge capital for EB-5. So very large financial commitment to this project. It's a $300 million project in total cost, and is $28 million of EB-5 capital. That project is very close to being fully subscribed. So if there's any interest in that project, we would need to get people in the queue as quickly as possible before that one closes out. The second project is a development in Las Vegas called Circa Las Vegas. It's a new resort and casino hotel that is going up in downtown Las Vegas. It's an exemplar approved project, which basically means that USCIS has reviewed the project and all the different EB-5 components and has approved it as qualifying under EB-5. That is a substantial benefit to investors because it gives them comfort that the project will not be denied. And as far when their individual petition goes in, so it significantly mitigates that risk. It's going to be a very large development. It's a slightly over $1 billion in total cost. It also has lots of job creation, over 40 jobs per investor. It's also fully financed, meaning the developer has bridged the EB-5 money. They're putting in over close to $500 million of their own money. We evaluated some of their other holdings, notably the D Hotel and the Golden Gate Hotel, which are also operating hotels and casinos in Las Vegas. They are extremely profitable and both debt-free. They've been operating and developing these types of projects for over 10 years. And it's a very favorable structure. Again, very low amount of EB-5 in the capital stack, around 9%. So $99 million of total EB-5 money coming in. And they have a senior debt piece from a variety of, from a syndicate of banks and investment banks of $450 million that will be coming into this project. You can go to circlelasvegas.com to see more about the project itself. And lastly, the Flying Biscuit Cafe. It's an established franchise that is headquartered in Atlanta, Georgia. It's been around since 1993. They currently have over 20 operating locations. They've never closed a location in their 26-year history. And that is a testament to their business model and their the high quality of their food and high quality of their staff and the high quality of their training and all the things that go into making a franchise successful. The structure of this project is, as I mentioned, direct pooled. So basically, it will be reliant on the locations to be have full-time, over 10 full-time jobs per location, to fund 6 new locations in Dallas, Texas. Right now, the conservative estimate is that there will be 15 jobs per investor, although there will likely be more based on the franchisor's experience. And based on that, and mentioning that experience, the person that is leading this, the franchisor, created many very successful franchises from scratch in the past: Planet Smoothie, Moe's Southwest Grill, Mama Foo's, Dot Greens, and a few others, and has a very experienced and seasoned franchisor. In this particular offering, the investors will hold a majority interest in the locations that are created until they get a return of their capital, once they're eligible to, and the franchisee that operates these locations will be will be investing $100,000 each of their own money into each location. You can learn more about the franchise itself by going to flyingbiscuit.com. We have the opportunity for information on all of these projects, and we'll look to obviously answer any questions that you have about these projects, and can as we go through and learn about your situation, we can help guide you toward the investment that might be right for you. So with that, we'll entertain any questions. I'll see now if we have any questions. Do we have any questions? Let's see here. All right, we don't have any open questions. However, if you do have some, please submit it, or you can contact us at the email addresses and phone numbers that are on the screen right now, either Robert or me. Oh wait, let's see if we have one. Do we have one pop up? The question here is, do these projects have an ROI? So the answer to that question is they all do have a return on investment. Each project is a little bit different. The let's see, sorry. The New York project is 1.25% per year preferred return. The second project is 3% preferred return per year, and the Flying Biscuit is 2% per year preferred return as well. So all those are obviously subject to the success of the projects, since none of the returns, annual returns or return of capital, can be guaranteed. But we all feel confident that investors will earn and be paid those returns. So I think we have all right. Let's see if we have another question. Well, if I didn't answer the question in what I just said, please email me separately at mxenick@investamericap.com or mike.xenick@investamericap.com, and I'll be sure to give you a more comprehensive answer. Any other questions? I think we have one, and it represents, it's related to representation in Brazil. I will respond back to you separately on the answer to that question. All right, do we have any other questions? All right, well, with no other questions, thank you for participating today. Thank you again, Robert, for your participation. And again, if you have any further questions, if you'd like to see the webinar again or refer it on to other people, we recorded the presentation today, and it'll be available for replay. We'll get that link out to everybody on the list. And if you have any questions or would like to speak to us, please contact us directly. Thanks, you,
Mike.
Thank you, Robert, and thank you, everybody. Good luck in your pursuits if you're pursuing EB-5, and we look forward to speaking with you.